Hello, everyone. Welcome back to another episode of the Divorce Differently podcast. This is the 7th episode in our special series of divorce talks with Erwin Mitchell. Today, we're talking about what happens to the family business in divorce. When a couple separates, the conversation about finances is unavoidable. But I've found that few topics spark as much confusion, emotion, and complexity as the family business. For many couples, the business isn't just an income stream. It's a legacy, it's a shared project, and sometimes it's really the center of family life. So when divorce enters the picture, people are often unsure what happens next. Is the business considered a matrimonial asset? Can one partner keep it? What happens if one or both spouses are working in the business? So to talk about this topic, I've invited Marie Kilgallen. Marie is a partner in the Birmingham family law team at Erwin Mitchell, and she brings over 20 years experience advising on all aspects of relationship breakdown. She specializes in complex financial matters on divorce, including cases involving business assets, trusts, property portfolios, and pensions. Marie, thank you so much for joining us today.
Thanks, Chloe.
So how are businesses treated in divorce? Because they are an asset to be considered, and it's usually one that's very emotionally loaded, as I was saying.
Absolutely. The business can often be one of the most valuable assets. I think the starting point when looking at a business is you have to think about where the business came from. So one of the things that I explore with a client from the outset is this a business that the husband and wife perhaps set up together during the marriage?
Mm-hmm.
Or is it a generational asset? Is it a family business that's being passed down through the generations, which can make a difference to how we treat the business and how we may want to preserve it for the future. And another thing to think about with business assets is they're often run perhaps by one party, maybe with some involvement from the other party, or maybe none. And there can be quite a level of distrust or lack of knowledge. And so we're dealing with all of those emotional factors as well as the practical steps about including the business as part of the matrimonial assets and what value you place on the business.
And is the default position that it is a matrimonial asset, and unless it's proven elsewhere differently, or what's the stance on that?
Absolutely. The business in any divorce would be considered as one of the matrimonial assets. We do have an emerging area of law where we're looking at the source of that asset. So perhaps if it is a generational asset, we may want to look at what the value of the asset was or the business at the time the parties began to live together or began to marry, and perhaps to look at whether there's been any growth in the business during the course of the marriage and whether that's attributable to either party. So there is complexity around when the business started, what the parties did to grow the business during the marriage. But the starting point is always to think about what the value of that asset is in the first place and value the business, and it becomes part of the calculation. And we then have arguments as to how much of that business is included or excluded as we move forward.
And that's really helpful, actually, because I think people don't always realize. So when it's intergenerational, then it's a separate kind of situation. But even if it's one of the two in the couple who's built this business and the other wasn't involved at all, it's still a matrimonial asset if it's been built during the marriage, right?
Yes, it is absolutely a matrimonial asset. How we treat it and what we do with it can be very different to how we treat cash, for example, or how we treat a property. And that's where the complexity can come into looking at what the outcome should be. What we aim to do really is try and simplify it as much as possible because it can become very complicated.
I can imagine. And I guess one of the big issues is how do you value that business? And you touched upon it a little bit with that idea of, the intergenerational piece. But even if it isn't intergenerational, how do you go about valuing that asset, which is, it has debts, it has revenue, it has all sorts of different dimensions to it?
Of course, the first step is always to think about, is the business a capital asset or is it actually an income stream? So if you think about people who undertake trades, perhaps a plumber or an electrician, or they may well be just a business and it may be a company registered, but actually the purpose of that business is simply to produce an income. So you have to establish at the outset what type of business it is. If you determine it is a capital asset, perhaps it owns property, maybe it's a rental company, or perhaps it owns premises, maybe it manufactures a product, then what you will need to do is gather as much information as possible and put a team around the client. That's what we aim to do. That may include an expert, so maybe an accountant, so not to get too technical, but often on a single joint basis, which means somebody acting for both parties to value the business.
Yeah.
It may well be that what we do is put an accountant in the background, so as a shadow, and they act on behalf of one party, perhaps to question any of the evidence that's been presented. One of the difficulties with valuing a business is that the information often comes from the business owner. It's not an audit.
Yes.
And there can be a level of distrust about, are the accounts accurate? Are they up to date? Is the business owner deliberately trying to run the business into the ground, so to speak? And so making sure that we are being as forensic as we can, whilst being cost effective and taking a proportionate approach, is absolutely crucial. When you then move on to valuing the businesses, we put that in the hand of experts, just as we would put a client in your hands to provide them with coaching support. And we rely on the accountants to identify the best method to value the business. There are various different ways. But having a lawyer and having a shadow expert behind and having as much information as possible is absolutely key.
Yeah, and I think I've certainly seen it in a lot of cases I worked on. There's a concern with the trust, and sometimes selecting that accountant can be a pretty important decision. Is it traditionally not the business's accountant? It's a third party who's new to the situation, who hasn't been biased by it.
Very, very usually. Occasionally, the business accountant can be very helpful. They normally have all the information at their fingertips, and they also have the knowledge. But if we're looking to have an impartial assessment, then we would appoint somebody as an expert. And one of the benefits being Owen Mitchell in a larger firm is that not every accountant can value every business. Valuing a business such as Tesco, for example, versus a hotel versus a leisure company requires a different set of skill. And so identifying the right expert is really quite important.
Yeah, that makes sense. So that's an important decision for people to be making, is who is that person? And I assume there's some negotiation or conversation around who's the best person to appoint at that stage.
Absolutely. Process-wise, we would normally get a copy of the expert's CV, look how long they may take, look at their previous experience, and it would be a definite negotiation to select the right expert for the right job.
And so how does it work in practice then, while all this is unfolding, when you've got both spouses that are involved in the company and they're both working, together in this business? How does that get handled during the divorce and even afterwards, if one of the two is an employee, for example?
With very much difficulty, I would say. My view would be that if you are assisting a client and they want to keep a business running and the parties are doing it together, that should really be one of the first conversations that they have before we even go down the route of valuing the business. It's to agree, what roles are each party going to carry on playing in the business? Are we going to keep the income streams the same? Are we going to maintain the employment rights? I think that's really, really important. What we don't want to do is kill the goose that lays the golden egg. That would be detrimental to both parties, absolutely. And so whilst it can be tempting, particularly if bitterness sets in, for one party not to support the other party in the running of the business, or perhaps one party to suddenly terminate the employment rights of the other party because it's the right thing to do, it can be quite catastrophic financially. So my view would always be at the very outset, perhaps via mediation or a negotiation, to think about, do we want to keep this business going? Do we want to keep it profitable? And if so, how do we do that? That's the first thing to do. Then we move on to, well, actually, what are the assets of the business? And then let's get it valued. And then we move on to the really difficult question, which is, what do we actually do with it once we know the figure? How do we deal with it at the end of the case?
And how would a court treat a situation where both spouses are heavily involved in the business and they're both, it's truly a joint venture? How do they decide who's going to keep the business if they don't want to keep working together? Would they look at whose idea it was, who's the most skilled worker? I don't know how they go about that.
Possibly. I think it would depend really on the strategy or approach of both parties. Are there many married couples who are going through a divorce who want to continue to run their business? I would suggest that perhaps not many, but we do come across it, and we absolutely would, in that circumstance, if it's by agreement, we would draw up very careful terms, perhaps a detailed shareholders agreement to define roles and responsibilities and who's getting paid what. A court approach, in my view, would probably be more simplistic. I think they would look at actually who established the business, who's doing more of the day-to-day work in the business, who's going to help to move the business forward. I think a court likes to be practical and simple. And there are three options really. The first, and I have seen this happen, is the court will simply sell the business and order it to be sold. Now, that's a very easy decision to be made. Let's sell it. But who's going to buy it? And finding the buyer is very difficult. And what price will they actually pay? Is it the same as the valuation? What skills will they bring to the business? So selling the business can often seem like an obvious solution, but it's not always the most straightforward. The second option is that both parties stay working within the business and have defined roles and responsibilities. I'm not sure a court would necessarily impose that, but it's definitely an option. The problem with that is that perhaps you may say that we're keeping 50-50 of the shares in the business and we'll share the profit. What's to stop one party going and setting up a rival business necessarily? What's to stop them starting all over again? And so if you're setting off assets and saying, I'm going to keep my business because it's worth something, but the other party doesn't cooperate and perhaps sets up their own business, that asset can then soon become worthless.
That's true.
And so I think actually what needs to happen is clients need to have conversations, whether that's with lawyers or with coaches at the outset, and think about what is it they are seeking. If they are seeking security and stability, they may not want to carry on running a business or hold shares. They may want to have cash or property, in which case the set-off approach, whereby one party keeps cash or property and the other party keeps the business, may well be the appropriate approach.
Absolutely. And so it really depends on the situation. There's a lot of different models people could look at. One thing that came to mind as you were talking is if the couple does decide to continue running the business together, does that prevent them from getting a clean break, or can they still have a clean break in their financial order and have that asset that they continue to jointly own?
Again, it depends on how it's structured. I would say that they should still aim for a clean break. That's the duty of the court, is to try and achieve a clean break. But it has to be a clean break with defined terms and conditions. So perhaps it would be a clean break consent order, but backed up by employment contracts, backed up by shareholders agreements. And what you actually do is dissolve the financial claims between the parties, but you leave them financially connected as directors or shareholders, and so it becomes much more a business transaction rather than a relationship transaction. And that would be the appropriate way. It may well be that there's a level of distrust. You may not want a clean break. You may want to keep perhaps maintenance claims open in case you're relying on one party distributing dividends and perhaps they don't. So it may not be appropriate in all cases to be a clean break, but that should always be the aim.
Yes, I agree. And so how do you handle things when one of the two is employed in the business? Because I've had clients where they were working for their spouse's business. And of course, once the divorce starts looming, they are either, squeezed out or simply fired. How would that get handled? Is there a way of guaranteeing their employment, or is that completely separate to the divorce conversations?
It's a combination of both. Again, it's complex. What we'll try and do is simplify it. If one party is employed, and very often it's the wife may be employed by the husband's business for tax reasons. If it's the wife who's employed perhaps and she's exited and the employment terms haven't been followed, perhaps she hasn't been made redundant, she hasn't been dismissed properly, then she would have an employment claim as an employee. And so we can certainly assist with that employment claim. But moreover, what that party would be most concerned about is probably the loss of income that comes from that. Because obviously if you're no longer employed, you're no longer getting your salary. And we would deal with that by way of maintenance, because if you've left somebody out of a job and they no longer have an income, then you've created a hole that needs to be filled.
So strategically, it's not necessarily a good plan for the person who owns the business.
Absolutely. I would caution them against that and say, really, a bit like dealing with the interim position at the very beginning, it's got to be part of a package, because it can be short-term thinking to think, I'm getting my wife out of the business and I'll save some money by not paying her. She'll still require that level of income to run her life or run the house or look after the children. and it will just have to be paid from a different pot until we can wrap it all up in a package and look at the overall settlement. So perhaps it isn't the most sensible thing to do sometimes, but I understand why people often act in haste and then perhaps think to themselves, well, maybe that wasn't the most sensible decision. So getting that really early advice about how you're going to manage the business is, on both sides, is really important.
And potentially building that employment conversation into the negotiations.
Absolutely.
So I'm trying to think a step ahead to people who are building a business as a married couple. What is it that they could do ahead of time, upstream, to try and protect the business at the time of divorce, if there was a divorce?
I think that early planning is absolutely key. So lots of business owners will set up a business either pre-marriage or during the course of the marriage, and they will take advice from their accountant or from a company set-up company who will help them with logistics. They won't think to get the legal advice. And the accountancy advice without the legal wrapper, it's not useless, of course it's not, but it would give so much more benefit to have the legal advice at the same time. So dealing with it separately, if I'm looking at it pre-marriage, so perhaps you're in a cohabiting relationship, and perhaps, you know, your parent comes to you and says, I'm about to retire, we're going to restructure the shares and I'm giving you the business ahead of you getting married, perhaps. A prenuptial agreement is absolutely crucial. And a prenuptial agreement can deal with what your divorce may look like in 10, 15, 20 years as a whole package, but it can also deal with a discrete issue. So it could simply say, we're not sure how we're going to deal with our finances if we get divorced, but we do know that this company came from grandfather and grandmother, and we want to ring fence this company absolutely. So we can do it on an item by item basis. So a prenuptial agreement is absolutely crucial. I would then also get some advice about whether you do make the other party, perhaps, do you make them a shareholder? Do you make them an employee of the company? Do you understand what that means if you are to divorce? You can't just simply take someone's shares off them. There's employment terms, and you can't just get rid of somebody without potential consequences. So thinking about that, it might be tax efficient, but is it a sensible step?
Yes.
And certainly, if you're already in a relationship and you're, well, a marriage rather than a relationship, we can talk about doing a post-nuptial agreement. The difficulty of post-nuptial agreements is prenuptial agreements have the leverage of the marriage. If you don't sign, we won't get married. It's never as harsh as that, but it has a leverage. A post-nuptial agreement, obviously, you're already married, and so it's much more difficult, perhaps, to get a post-nuptial agreement. But it could be, if you're the parent passing down the business, you may say to your son or daughter, I'll pass the business down to you, but I want it to be ring-fenced in some way, and I want you to enter in a post-nuptial agreement in order to do that. So there are various documents we can put in place, and they are very, very sensible, because whilst prenuptial agreements and post-nuptial agreements are not binding as a matter of law, the court is absolutely clear that if you are a grown-up and you take advice and you understand what you are signing, you should expect to be held to what you have signed. And so getting that wrapper of advice, accountancy, legal advice, perhaps relationship advice, all at the same time is really, really important.
And I guess the question that's coming to mind is, at what point do you do that in the development of the business? I just finished a book. There's a biography of Bobbi Brown, the makeup artist, and she, you know, really was just something she was doing on the side, and it started to snowball and to gain traction, and to suddenly she was bought out by Estee Lauder, and it grew and grew and grew. And so it's, at what point do you decide that this is something that's now starting to be valuable, and do we put these kind of arrangements in place and really think about what's going to happen to this business and how it would be treated on divorce? What would be your recommendation?
And that's a really interesting question. The obvious answer and the easiest answer would be from the very beginning. Ideally. But actually, when you are starting a business, that's not going to be your main focus.
No, especially if you're doing it in your kitchen, right? You know, it's not anything serious yet.
Absolutely. And how many of those entrepreneur stories have we heard? And particularly, we now live in a generation where the old-fashioned job, you know, going to an apprentice at the age of 20 and you work until you retire at the age of 60, that's not how people acquire income anymore. There's people have, you know, multiple income streams from different opportunities, and who knows which one of those is going to potentially take off and perhaps become very valuable. So it's difficult to know. What I would say, and my plea really, is that If you are advising people, perhaps you're an accountant, or perhaps you are helping people establish companies, to think about, does your client need that advice? Because the person who's starting the business may not know. It may not be the client who has that awareness. But certainly if you're an accountant and you can see that your client's business is taking off, and perhaps for the first time they're having to pay VAT, or they've just had a very significant tax bill, or perhaps they're starting to think about a share restructure, or they're looking for investment from private equity, or bring other people on board, that's the point that would tell me that actually this is growing into something that needs to be perhaps protected, and it won't be the business owner's first thought. So again, that team approach is really, really crucial.
Yeah, that makes a lot of sense. That's really good advice. So before we wrap up, I always like to ask my guests for their top 3 tips. So I guess in this context, a family who has a family business and who are starting to explore divorce, what would be your advice to them? What would be the top 3 tips for them?
I think the first piece of advice would be, don't act in haste. It's very, very easy to feel a separation means that everything should be done all at once. And perhaps you may have one party who says, I'm no longer supporting you in your business. That's what destroyed our marriage. You were a workaholic. You have another party who may be in the business and thinks, I'm going to take my foot off the pedal. Why should I carry on working so hard when my ex is just going to benefit from it? Don't make those decisions in haste, because ultimately the divorce and the separation are a process. They will end, and you will have to be able to move forward. And you'll want to have a successful business. You'll want to be able to provide for yourself and your family moving forward. So, as I say, don't kill the goose that lays the golden egg, would be my first piece of advice. My second piece of advice would be about generational planning. We hear lots and lots of stories about parents who are passing on wealth. The obvious is obviously passing on wealth, perhaps for a house deposit, but it applies equally in the context of businesses. They perhaps bring in their children to start working in the business. They may then bring in their spouse for tax reasons. They start to employ them. And so if you are thinking about passing on a business, or you're thinking about involving more family members in a business, perhaps pause and just get some generational legal advice around business. So that's not necessarily a divorce tip, but what that does is potentially prevent all of the issues that are really hard to unravel as part of a divorce. And that thinking ahead piece can be really important. And then I think the third tip is that if you are in the divorce process and a business is a significant asset, is to really put the right people around you. Get a lawyer who specialises in business assets. Perhaps a relationship coach who can help you really think about what is it you want out of the process. Do you really want to carry on being involved in the business? If you are, and then think about the right accountant. So have your lawyers got the right contacts? Are they able to differentiate between the right people who are going to be perhaps looking at this fully forensically, and thinking about the value of that particular business? And so I think that's really crucial, because once you have a valuation of the business, it's very, very hard potentially to pull back from that valuation. So getting it all right in the first place is really crucial. So that's what I would say.
I like that last point around surrounding yourself with the right people. And I think that's something that sometimes people try to cut corners, saying, oh, we'll just use our friend who's an accountant or something like that. But if it's really a significant asset, it's really not something you want to be improvising, and it's worth taking the time.
Absolutely. I think that's really crucial. And also recognising our own limitations. I often say to my clients, I'm a lawyer, I'm not a counsellor, I'm not a coach. But I could consider value in that service, and that's that level of support. And so as lawyers, sometimes stepping out of our comfort zone and thinking, well, what else can I do to support my client and really help them understand this process? Because there's nothing worse than a client who feels completely overwhelmed with paperwork and terminology and requests for information at what is already a stressful time. We have to try and make it as easy and simple and supportive for them as possible.
Thank you so much, Marie. I completely agree. And thank you for all your tips, your insights, and all the information you shared today.
Not at all. Thank you.
Have a good day.
Thanks, Chloe.